Tsotetsi, which was formed by Latin American state. In 1990s, many internal wars started to happen and many coups d'etats, which is why the direction of the Union started to change a bit. And ultimately, on the 9th of September 1999, the African Union was formed. I think it came into force in 2000, but there they formed it, by a conference that was called into place by Gaddafi. We then discussed whether this was just old wine in a new bottle, but found that the African Union had new states and also new priorities. We then discussed the objectives and principles of the African Union, found that there were some objectives that were already there in the Organization of African Unity, some that were not there but complemented the old objectives, and some that were quite simply contradictory. For example, in regard to non-intervention, which was back then valued quite highly, and now, as we also discussed with Judge Tadi, intervention is actually quite unique in this regional organization. Also, peace and security was included then, and specifically, unconstitutional changes of government were no longer tolerated. We then talked about cooperation and integration and asked where in this sphere the African Union would be located, and found that it is an organization of cooperation that is moving towards integration, and that in some ways it is following the example of the European Union, for example, in the role of the Commission, but that the comparison is rather nonsensical at times. We then discussed the organs of the African Union, the organs that are listed first in Article 5, Paragraph 1, but also that the Union can form new organs as per Article 5, Paragraph 2 of the Constitutive Act, such as, for example, happened with the Peace and Security Council. We also found that there were some organs or institutions that were not listed, but integrated from the earlier Organization of African Unity. And we discussed that the African Court of Justice still does not exist because the Protocol of Malabo is lacking some ratifications. We then discussed that there were two different types of organs within the African Union. First, sovereignty organs, meaning the members of these organs are representatives of the state and fight for the interests of the state. This is, for example, the case with the Executive Council. The other type of organs were integrated organs. The members are still from member states, but they are independent experts and are in fact prohibited from taking guidance from any state. So they represent the interests of the African Union in its entirety. This is, for example, the case for the Commission. Next, we went to the Protocol of Amendments, which also lacks ratifications, and we discussed specifically Article 12 of that protocol, which wants to eliminate Article 31 of the Constitutive Act of the African Union. That article defines the cessation of membership. We found that technically this would not be too relevant because the law of treaties in the Vienna Convention on the Law of Treaties on Customs still provides for the possibility to leave a convention, but yet this is stopping some states from ratifying the protocol because it is not a good sign in what direction the organization is moving. We also discussed who would be bound by decisions made by the Peace and Security Council and found that it is not just those who specifically ratified it, but since everyone ratified the Constitutive Act of the African Union, which permitted for the formation of the Peace and Security Council, every member state of the African Union is bound by its decisions. We then went to the instruments of the African Union and found that there were three groups classed by their legal quality. First being conventions that every state has to sign and where the African Union is merely a forum for the formation of these conventions. Then we have decisions taken by organs that are binding upon all, and last we have soft law, so instruments that are technically not binding but still show, for example, help in the interpretation of law and give guidance such as recommendations. The different forms that acts can take are therefore, for example, recommendations, decisions, but we also have regulations, which are technically binding, but leave a bit of room in its interpretation or in its exact design. We also discussed that the African Union does not need to have a common position when discussing something in the United Nations. They will find a common position in advance, but the member states are not required to adhere to that position. We compared that to the European Union, where the member states will not even, if it's in the exclusive competence of the European Union, speak on their own behalf. We discussed how decisions were made, discussed that the Commission usually creates reports on certain topics, which the permanent representatives review and forwards to the foreign ministers, where then the Executive Council adopts decisions. We discussed the problem of a lack of a court, that there's no enforcement mechanism, but there are mechanisms of sanctions, but no access for individuals to claim their rights. We then ultimately asked how decisions of organs can be controlled and found that it is rather quite hard. We compared that to decisions of the UN Security Council and to the Cardi case, when individuals sued the EU Commission for complying with the UN terrorist list without checking it independently, where the European Court of Justice did in fact review a Security Council resolution, but that is rather unique. And as a last point, we discussed if the African Union may intervene according to Article 4 and found that it was written somewhat complexly, and found that different interpretations could be that all intervention by the Union would be prohibited, or that the Union simply could not promote or encourage interventions by member states, but that itself, under certain circumstances, could intervene. Then we moved on to the class of Dr. Makong, where we discussed first what the value, or what makes up the value of goods. You probably remember the example of the iPhone, where we found that the biggest part of the value is actually not the physical parts of the iPhone, but the intellectual property, the design behind it. We then talked about the objectives and principles of the African Union, which are, first of all, to get rid of the contradictions and inconsistencies that are currently in the multiple trade agreements on the continent, but most importantly, to form a continental single market for goods and services. In order to do so, this would mean that within Africa, first of all, no import duties could be raised. It would also mean that Africa needs common regulations, as for example, in regard to the labeling. It would mean that the African states need a common external tariff, meaning the import duties must be the same for every country. And that last, you would need the free movement of persons. We also, however, found several problems in establishing exactly that. First of all, that there are so many different agreements with third states. Countries that have currently no import duties would either have to renegotiate to raise their duties, which is quite difficult, or countries with import duties would have to lower their import duties to zero, which obviously they are quite reluctant to do. We then additionally have the most favored nation clause, which means that if a country were to lower their import duties for a certain product, they would have to do that in relation to every other state. We then discussed Article 24 of GATT and Article 5 of GATT, which both state that when you have such regional agreements to open up the market, you need to liberalize 97%, or a substantial part, which amounts to 97% at least, in order to be able to do that. This is also quite a high threshold. This is why we found that theoretically a common single market, a common continental market, would be possible, but that is rather not practically possible, or at least not in the near future. Thank you so much.
Invite Dr. Makong to continue. Thank you very much.
All right, thank you very much, and good morning, everyone. And I know that yesterday we were cruising, so we didn't have a moment to have you ask questions. So if you have a question, as of the discussions we had yesterday, you may raise your hand or forever hold your peace. Right. Yes, please, sir.
Much. Yeah, yesterday we had so many questions, but we didn't have a chance to ask because of time. I would like to ask about the intellectual property rights. Under WIPO, it's allowed, they have allowed developing countries to use like for instance, the intellectual property rights of the medicine, like these are that are very vital. For instance, the HIV/AIDS treatment, this antiviral medicine and so forth, COVID and so forth. Now, look what the way the U.S. Was bullying African countries. Trying to ask for minerals. If you don't give me these minerals, then I'll cut out all the aid funds and so forth. So why can't African countries? Why is it that African states have never taken advantage of the fact that the patent is waived? They are allowed to invest in pharmaceutical companies to produce their own HIV/AIDS medicine. Thank you.
Yeah. No, it's a political economy question, and I'm glad that we have people from different countries in here. And like I said, I had the privilege of sitting in negotiations. And the reason why I keep on going back to negotiations is because negotiators are equivalent to your parliament back at home, because they are lawmakers. So we sit and then we write different rules. For example, but let me take you back. The principles that you have that we discussed yesterday and the objectives of the AfCFTA, I had the privilege of holding the pen to put all those things down. Yeah. Oh. Okay. So I can give you a history of what actually happens. And he's talking about a concept of compulsory licensing, which we fought for as Africa, to make sure that we do have the capability to provide people who are exposed to HIV and AIDS the possibility to get the medication. Why? Because the big pharmaceutical companies from the Western countries had patents and rights over these particular medicaments, and they would sell them to Africa at a highly inflated price. And the way it works, and I worked for government, and I can tell you this. If your government, for example, and this is what happens for most African countries, if you look at your national health budget, a big portion of it, you'd find that it is externally funded. Did I tell you about my minister? I told you about my minister, right? When he wanted to have a budget line on HIV and AIDS related, government activity, and then the World Bank guy said, no. This is what happens. In some of these agreements that our government sign, and I'm talking about contracts that we enter into, there would even be prescription as to where the Ministry of Health should procure drugs. So in the context of the question you asked, we fought very hard, and this was around 2005, to make sure that we also can be in a position to bring in the reverse engineering, and that was totally something agreed. But the Western countries, of course, remember, when you talk about the pharmaceutical companies, yes, they make money, but they survive on government subsidies as well, which is the innovation part of the work that they do. So huge subsidies go into that. So here we are, we think that we have won, and South Africa, as you know, there's a case, they tried to manufacture some of these drugs. It was prohibitively expensive to do that. Remember, for you to manufacture drugs, it's not just you going to the lab. The lab, you need a certain special equipment to do that. It's just not the question of getting the formula. No, it's a whole lot. It's not just you being able to reverse engineer the chemical processing of coming up with a drug. There are many other things. You have to get the right equipment, and you have to make sure that, of course, you procure them. And those who owns this equipment? The same countries. I beg your pardon, the same companies. All right. So, I like what President Obama said. He's not my favorite person, but I like what he said. He said that he was asked a question, what do you hate the most about working with people? And he said, I hate people who make complex matters seem to be so easy. And I like that because if at face value, you look at the headlines, so all no developing countries have won on any issue, and you go deeper, you'll find actually that no, that's not the case. I sat in many negotiations at the WTO on we have a group of least developed countries from all over the world, and of course, majority of least developed countries are from Africa. So we sat to negotiate TRIPS Article 66.3, I believe, 66.2. That is TRIPS Agreement of the World Trade Organization. That compels the developed countries to incentivize the transfer of technology to African countries. It's in the WTO agreement. You think that, they would do that? You think that, and I don't want you to, like I said, I don't want you to think about it as them and us, because that's not the way to think about it, at least from my perspective. Are you saying, let's say, colleagues from Germany, right? You have huge pharmaceutical industry. Let's assume we do an assessment as to how much of the drugs, vaccines that are manufactured by your companies are exported to Africa. Now imagine if you're a company, right, and you are making a killing because Africa is dependent on third countries when it comes to pharmaceuticals. We don't manufacture enough of pharmaceuticals. We depend on what others send to us. So now think about that. Are you saying that you want to kill that German company so that you have the capability to produce the same products in Africa? Who would do that? Are you saying that you want to create unemployment in Germany so that you can benefit, and for free for that matter? Do you think anybody in their rightful mind will actually just roll the red carpet for you to do that? Do you think that the companies in Germany will say, no, we are benevolent companies, we just want to ensure that African companies can compete with us and even eat out our market? You think that in business, that's how people think? People, we in the continent, we are trained to be emotional. We are trained to be emotional, to say, no, they don't want, and we become very emotional. But did the Chinese do that? No. Nope. They said, we're going to open up our markets for you. Here are the terms. You gotta have a joint venture with a Chinese company. If you want to manufacture these products here in China and have our huge market, you gotta have a joint venture. You gotta enter into partnerships. By the way, these are the terms. There's gotta be technology transfer in this way and that way. And they have in their system, within government, they have entities within government that monitor exactly that, to say there is transfer of technology. Not this thing of us, the only thing we think about in Africa when you have a company is people thinking about their stomachs. To say, no, we need someone to be there in management. I mean, come on. What difference does it make if you're in management? Imagine if the term there is that you gotta have somebody who gets trained technically, the scientists. Now it's different now. To say, no, you gotta support a certain, I don't know, if you have, let's say, like in my country, we have a nursing school and they have a section of it that deals with pharmaceuticals. You gotta make sure you invest in that and introduce new courses, introduce new technology so that there's mass production of people with skills in it. No, that's not how most of us think. So I always say that it's not it's not, okay, let me put it this way, if I can console you. Maybe you would say I'm not African enough. If I was the US, if I was Switzerland, if I was Germany, I would do exactly what they're doing. Why should I create difficulty for my own people? Now, this is money. This is money. The same money that you get through the World Bank as a loan. Where is it going when you buy drugs? It goes back to the countries that are shareholders in the World Bank, and you are not one of them. It goes back. So you see the way it works. You give a company a subsidy. Tanzania takes a loan. Tanzania is compelled to buy the drugs from the manufacturing companies from these countries. You buy, right? You change your Tanzanian shillings into dollars. The dollars, they go back to the pharmaceutical companies. You see how cyclical, how it works? Yeah, that's how it is. It's a system. So I said in many of the negotiations on intellectual property rights, including as part of the LDC group, including on TRIPS Article 66.2, and please look at it when you have time. It talks about, it's a beautifully drafted article. So then we had a number of engagements on this. So we said, and then we said, this is lawmaking, right? We even have decisions at the WTO. We even drafted decisions on these matters. Drafted decisions. So we said, we need an assessment as to what extent have developed countries implemented that particular provision. Man, the guys, they came with the report. I don't know if they have trained 5 people in Tanzania. It will be there to say we are transferring the technology through training. You see what I mean? So, I mean, it really amounted to zero, nothing. Because nobody, even yourself, like I said, if you're in that position, you will not. You will not. And I think we are not, the idea that, most African countries come with this begging bowl mentality. The Chinese have shown us, no, that's not how you go about it. The Indians are now showing us that's not how you go about it. You come up with policies that are targeted. Where you need to shut down the sectors, you shut down the sectors. Where you need to subsidize, you subsidize. Where you need to introduce import licensing requirements, you so do. Where you need to introduce policies on local content, you so do. And that's what other countries, developed countries, would do. So I wish I was teaching you a course on political economy because I could say certain things, but I will not say them here. All right. So that's the best I can do on that particular issue. So like our colleague said yesterday, we discussed. Oh yes, please. Oh no, there's a lot now. Yeah. Okay. I should switch.
Prof, I have 2 questions from what were being discussed on yesterday. The first question related to the common external tariff. On yesterday, you tried to address on AfCFTA rules, where you say that they try to propose existence of same or uniformity charging of common external tariff. I want to know, drawing attention from the East African community, where within the East African community we have uniformity on the charging of this related common external tariff. However, there is alleging fact that the existed regional integration within East Africa is not beneficial to all members state of it. So how do you think that AfCFTA rules will be effective measures to balance the economic disparity within the continent? That is the first question regarding the common external tariff charges and what have been proposed by AfCFTA rules. The second question is, my first question is, the last part, how now the FTA will be effective measure to balance economic disparity of Africa economies. The second question is on protection of folklore. On yesterday we addressed that African countries have been consistently insisted on the protection of this cultural tradition as a cultural heritage of African continent. However, under WIPO rules does not explicitly recognize them. In Africa, we have a regional framework for protection of this. Under ALIPO, we're having the Sokopond Protocol, which try to address the recognition of tradition and the cultural heritage of Africa. Now, don't you think the Sokopond Protocol on protection of traditional knowledge and cultural expression of Africa are effective for protection of African heritage itself, regarding rather rely to the WIPO rules?
The next question. Okay. Jarif, okay. Irene, number 23 is when I
My question is, you talked about the objectives of the AfCFTA, and my question goes that, does the AfCFTA complement or replace the treaty or the Abuja Treaty? And if it complements, we see at the treaty under Article 4, it talks about the objectives, the same objectives. Why should we rush creating a new protocol while we have not finished the existing one? And we can see the custom union, we haven't finished yet. Most of the recs haven't finished it, so yes.
Vous pouvez poser votre question.
Merci beaucoup pour la parole. J'ai une question.
Sir? Okay, wait. I think this one is not working. Who was the translation that is working? It's not working. Okay. C'est comme ça marche pas pour tout le monde. The translation from English to French, from French to English, is it working? Okay. What channel is that? Channel 1. Channel 1. It's working. Okay. Prof, channel 1.
Ok, merci beaucoup. J'ai une question. Est-ce que au niveau de l'Union africaine, il existe un instrument juridique, y compris aussi un protocole entre les deux pays des Grands Lacs, un instrument qui privilège les productions, les transformations et les productions des petites et moyennes entreprises dans les pays des Grands Lacs. Comme en RDC, et on sait que parmi les pays des Grands Lacs, la RDC c'est un pays vraiment non avancé dans le cadre des transformations et commercialisation de produits pharmaceutiques. Maintenant, est-ce qu'il y a un instrument juridique qui appuie les entrepreneurs locaux dans chaque pays dans le cadre de la coopération régionale sur le plan commercialisation de produits transformés et produits localement? Merci.
Thank you, Prof, for such a brilliant presentation. Actually, you've been inspiring me a lot. So congratulations for your analytical and critical mind. Your mindset is very important in terms of transforming Africa to the other stages of development. My questions are as follows, and I'll have a reflection of what you presented yesterday. What future reforms or enhancement do you think are needed to strengthen the effectiveness of this protocol? That's my first question. Future reforms or enhancement which have to be placed, which are to be put in place in order to strengthen the effectiveness of these protocols, right? And how inclusive are these protocols ensuring participation of small and medium-sized enterprises, as these are the key drivers of economy in African countries? And maybe I can just put another question. What impact have these protocols had on intra-regional trade volumes and economic growth? And then maybe general understanding. What do you think is African position in terms of penetrating the world powers, like the new world order, and the powers of IMF and the World Bank when it's come to development of Africa? Since these institutions are in place, but in a sense they don't want to help Africa to get rid of poverty. Instead, they are just putting some conditions which still jeopardize the interest of Africa in terms of development. I think it's high time now, we as African, we need to think by using our own brains how we can get rid of those hurdles from the imperialism and capitalism powers of the West, of the Western world. Since they are there and in actual sense they are not helping us. We have the IMF and the World Bank, but their policies are not really in actual sense helping Africa, but they are for the interest of others. And the last question you asked yesterday, why are these policymakers in Africa entering into agreements but they're not enforcing them effectively? I just want to contribute, everybody here, maybe in order to understand those issues, we need to integrate these laws, economics, and the politics per se, because in every governance structure, there is an interrelationship between the policymakers, business, and the politicians. They stay in between by using the concept of iron triangle. The policymakers, they receive either money from the business community, and then also the business community, they supply money to the politician. So this entire circle, if you are not in within, that's become a problem. When we have money, the money can influence policies, they can also influence the decision of policymakers. So in order to understand these issues, we need also to do the political aspect of it so that we can sail in the same boat. Otherwise, it's going to be a problem. Thank you.
Oh, okay. One last question. Please, a question is what is, so the comments will come as a plenary, so the questions the way we were taught in school. Thank you.
Thank you. Thank you so much, Prof. My question is with respect to the general objective number 1 in Article 3 of the AfCFTA. You mentioned that it will be extremely difficult to achieve this, the idea of a single market for trade and for goods and services. Customs union. So my question is, why have it at all as an objective if it is extremely difficult? I think you mentioned it might require an act of God, unless we borrow from human rights and speak of progressive realization.
Okay, thank you. I think we are set now. Please, you have enough to eat on. Thank you.
Thank you very much. I have an essay of questions. Let me start with the last question. I think that it is good to set an ambition to achieve something. And I think that to achieve a single market, it's something that started from the early days of the OAU. It's been a dream of African leaders, those who emancipated us from colonialism, to have one Africa. And I will not go into the politics of Nyerere and Nkrumah, as some of you have studied these issues as to the approach. But it's been a long-held dream to have it. And in a sense, it's multi-generational dream. And all of us, I believe, we need to understand this. It's multi-generational. And therefore, we gotta be patient. Whether it will happen in my lifetime, I don't know. But you gotta understand how the world is structured. When I started off the conversation, we talked about what happened in 1945. And I mentioned that Africa was not part of those who sat on the table to come up with the global economic system that has three legs: trade, finance, and monetary policy. I would say also investment, which came a little later. So 4 legs probably, but basically the 3. You know, it's like when you have a family and you have somebody who tends your garden. We call them garden boys, right? Is it that when you make a decision for your family, do you consider the garden boy? So think about 1945. And I'm not saying Africans were garden boys, but I'm simply saying when decisions were made, the rules which were created were not meant to work for Africa, were not meant to work for Africa. So what does that mean? And let's be, I don't want us to be political about it. I'm trying to hopefully manage to get you not to think emotionally and be emotive about these issues, but to be analytical about it. If you look at, even when Africa was emancipated, if you look at the infrastructure, meaning the investments made by the World Bank, these are contracts that our governments were entering into, the investments that were made. Do you think that even now, the investments that are being made now, do you think that those investments were made to interlink the continent internally? If any investor, I'm just going to make you feel so bad this morning about how the world works, because it's important for you to understand how the world works. The infrastructure that is being built, or that had been built and continues to be built, it is on the coast. It is on the coast. For what purpose? If you want Africa to integrate, why are you not linking Namibia to Kenya, Kenya to, I don't know, to Central African Republic, and you begin to see the railways that are beginning to crisscross across the middle part of the continent? How come nobody is interested in investing in that? Tell me, if I'm the United States, why would I be interested in linking Africa internally? Why would I? My interest is to get the raw materials. We are a continent that exports raw materials. And anybody who, whether it's China, whoever it is, who comes into this continent, they will propagate means and build the infrastructure to make sure that they get the raw materials. And if I was China, I will do the same. If I was the US, I will do the same. It's cheaper to get the raw materials. Why wouldn't I do that? You get my point? So I'm trying to say it's a multi-generational. The question that you are asking is because you cannot deal with it now. They will kill you. No, I'm telling you. I tend, when I teach, I become very open about what happens. There are things that if you try to touch, you lose your life. So, I mean, if you want to, go ahead. If you are ready to be Jesus Christ, please go ahead. And I don't want to speak politics. Yeah, there are those we know. We have the history of those who lost their lives in this journey. So I would like us to understand that it's multi-generational. And when I teach my political economy course with evidence, not hearsays and all that, I ask my students and I say to them, tell me, when colonization left the continent, did the legal framework of colonization leave? And we look into national laws of countries, you would find that a country has laws that were promulgated in the 1950s. It is still there. They can't touch it. If they try to touch it, ambassador of a given country will come to say, don't touch that one. So there are realities. as to how the system works. You understand? So it's gradual, multi-generational. And I'll say one last thing on this issue, making an example when it comes to infrastructure. I'm very sorry. I should apologize before I say this. Can you imagine how oxymoronic it is for a country to take a loan? You take a loan. You build infrastructure on the coast. The infrastructure facilitates the mining of your minerals, raw. They are exported out. And you are the one paying the loan. I'd like you to think about that. You have a garden at your house. You have vegetables, all of that, at your house. And someone says, it is so difficult to get to your house. I want to build a tarmac road so that I get to your house. But please pay for it. I'm going to build it, you pay for it. And I'm going to take your vegetables. So meaning you even pay this particular individual to build a road to come and take your vegetables. They take your vegetables. Then they go export them to their places. Then they bring the vegetables as processed food and you also buy. Any infrastructure project you look into the continent, please, when these people from finance say, no, a feasibility study was done. Okay, let me stop. I'm just saying there is the reality of how the laws, because all of these are within the construct of the legal framework that was set out in 1945. Let me go to the questions. So you see it's multi-generational. So I think over time, and the interesting thing now is we are beginning to have a multipolar world, and we are beginning to see countries that are having a different approach when it comes to Africa. Others want to invest in Africa. So you are beginning to see the changes beginning to start now, where I always say there's a difference between independence and sovereignty. Independent, yes. Sovereign, no. So we are beginning to see that the countries from the West and the emerging developing countries are beginning to look at Africa differently, where now they have to contest for the African market. And others are willing to invest here. Others are having problems with their demographics. They can no longer sustain production in their own countries. And they're beginning to say, we need to go and invest in Africa and produce in Africa. So things are beginning to change in a natural way. So you asked me a couple of questions about the enforcement of policies and the whole question about inclusivity. The issue of enforcement, and this is how I would put it, we've been in the WTO for over 30 years. 30 years. But African countries have not had the capacity to translate the WTO rules into their national laws. So we stop at ratification. When it comes to now to domesticate those rules, it becomes a bit of a challenge. And sometimes I understand why. I work for government, as I had told you. Imagine if you have taken obligations, let's say, to automate the borders, and we have to automate, like when you go to any border, there's got to be working internet, there has to be computers there, the infrastructure has to be there. Now, some borders in the continent, you'd find that maybe it's 5 people per day, passing by. You see what I mean? So some of the rules, good as they are, they may not necessarily make sense in our own context. Some of the rules, they would require a lot of money for us to implement. Some of the rules, because the rules of the WTO are pro-imports. You get the sense? They are pro-imports. So are you going to, if you go to the Minister of Finance, is the Minister of Finance going to invest? It depends on the size of the economy. You see what I mean? A small country like mine, if I were to go to the Minister of Finance and ask for a budget to implement those particular rules, honestly, she'll be like, you're crazy. Because you're going to establish institutions that are not going to work to administer the rules. Not that it's a bad thing. You see what I'm saying? I'm saying that there is a disparity between the sizes of different economies and the ability to administer those rules. Now, what am I saying? Now, the AfCFTA rules, the EAC rules are WTO plus, meaning that they are at a much higher level than the rules at the World Trade Organization. So if you cannot implement the rules at the level of the World Trade Organization, how more are you going to implement rules that are now even at a higher level, more demanding than the WTO rules? But there's some work that we are doing at the Secretariat at the moment, and I'm leading that work. We are going to undertake the diagnostic needs assessment, where we look at every single commitment that an individual country has taken and go to the country and assess the capability of that country across 5 areas. I developed a model that has 5 elements to it. The human resources capacity of that country to implement that commitment. Number 2, we also would be looking at the administrative capacity of that particular country to implement that rule. And here we're talking about the administrative law. Is the administrative law enabling for that particular individual or a collection of commitments that are related to be implemented? Number 3, the institutional capacity of that country. Does the country have the institutional capacity to implement that commitment or a set of commitments? Number 4, whether you actually have in your rule book the rules that mirror the commitments that you have made. Number 5, we are going to look into your infrastructural capacity, because some of the rules, for them to be implemented, they need the underlying infrastructure. If you automate, you need computers, you need servers, you need internet. Do you have that? What would it take? And then we cost those measures, we put the dollar figures, and we say to the government, this is what you need to invest in. We have not done this, but we think that within ourselves, this is something that can be rationalized. At least, of course, it means that over the years, our member states will have something that would be more of a blueprint. You know, these things that they call the Vision 2020, you know, those useless things. I'm sorry, I tend to be very frank about these things. I think they're very useless because nobody would have the capability to implement them, right? But we need to be very deliberate and go down to the details so that we know how to structure and forecast our own budget and what we'll be doing in a few more years to come. So you can even have a 5-year plan, and again, once we have done the assessment, we'll have the countries we're going to help them develop a business case, or if you like, a business plan. What are you going to do, when, at what cost, and who would be your partners, all of those. So we are taking a totally, at the AfCFTA Secretariat, we are taking a different approach on these particular matters. Can I finish the questions? I hope I'll be able to go to my slides. Maybe I talk too much. I'll be very, very, very brief now. How inclusive are the protocols? We have, including a question that was raised about the small and medium enterprises, we have a protocol on women and youth in trade. And that particular protocol has very important measures, including access to finance, measures on that. We just had the adoption of a regulation, a ministerial regulation, so that what they call the simplified trade regimes. They are what we call simplified trade regimes, where at the borders they allow the women at the borders and the youth at the borders to export their products duty-free without having to, again, to pay import duties. And they don't go through these rigorous requirements where you fill up very complex documents. There's something that they call rules of origin. If you sell this product, they will say, where did you get the ink from? Where did you get the paper from? They ask so many things about the product, and then they do a computation to say, no, is this product produced in Tanzania or not, depending on the computation of the inputs that went into it. They don't have to go through that. If you have your mango, and then they're declared safe for eating, you just pass through the border. So these are the measures. And I want to speak to this because it's a very important issue. Important, at least to me. I always ask this question. Who normally has the capability to comply with trade rules? That is the market players. So we have multinational companies, we have small and medium enterprises, we have small, micro, and medium enterprises, then we have unregistered traders. The reality is, it is the big companies that have the capability to meet the rules. But Africa, over 98% of the market players fall within the category of small and medium enterprises and micro, small and medium enterprises. Meaning the rules, remember where the rules came from. Remember the rules were created in the 1940s. Of course, they were negotiated in the 80s, but they were meant for advanced companies that have the capability to meet these particular requirements. There are so many concepts in trade. There are rules on, for example, on pre-shipment inspection. Imagine if you have a producer in Tanzania, they want to export their products to Ghana, and it's a small-scale producer. Now, this small-scale producer has to pay money to a company that is going to inspect their products before they can export them, and then they have to get a certificate. Where are they going to get the money to do that? Are we together? So tell me, in our own national systems, right? When any rule is introduced, isn't it that you would have to produce some sort of a feasibility assessment to the parliament, and then the parliament appreciates that, and on that basis, then the rule can be given? There has to be some sort of an assessment of some sort, isn't it? Not in our case. So this is the point that I want to make. Our market structure is fundamentally different from market structures of any other region in the world. Even what a given country, like let's say the advanced countries and emerging developing countries, their definition of a small medium enterprise is different from our definition in terms of the thresholds as to the value of that particular company. So the problem we have with the AfCFTA and any other trade agreement we have in the continent is that the benchmark is the WTO rules. Are we together? These rules are meant or were designed for companies with capabilities to comply. You're small, and these people, you guys, I'm looking at you, because I don't know whether it's your first time to be in Tanzania, probably not. It's your first time. Can you imagine? I'm sure you've seen when you're walking down the streets and a number of women with vegetables. It's vegetables everywhere. It's fruits everywhere. And the question is, why is Tanzania not supplying the rest of the world with fruits and vegetables? These are small, because the economy is not structured around big companies that would own thousands and thousands of acres of land. I used to drive around, Germany and go to Milan, and, I used to enjoy my drives. And, you're driving there, these are like acres and acres of farmland. This is not how this economy in Africa is structured. When you drive from here to Dar es Salaam, you're going to find people with little plots there, doing for subsistence. But those people, they also sell a little bit of what remains. So they are not like these big time, producers with a high level of production. That's why you don't see these big, farming machines. These big tractors, you don't see them here. That's not how the economy is structured. So you can see how there's a difference between our economy and the rules we have and the intention behind the rules that were created in 1945. So that's a little bit of something that I believe we need to be aware of. I think I'm over-explaining, so which is very bad of me. Just give me a second to open up. Okay, so there's inclusivity in there, protocol on women and youth. We also have inclusivity in the protocol on investment as well. So it's all in there. Is it to an extent that I would be happy with? No, it's not. But we are having some other initiatives to make sure that programs that we're developing at the Secretariat to go beyond the rules. The other question that was asked is about the change of the new world order. I think, my brother, the problem, the 1945, what they call the Washington Consensus, the outcome of the 1945, then it is rupturing. I think if you please do listen to the statement by Prime Minister Carney, the Canadian Prime Minister, the statement he did this year at the World Economic Forum. It is rupturing because whether you talk about the trade rules, and I wish I could speak about that, whether you talk about the trade rules today, meaning the WTO rules, I mentioned it in the first day, the WTO rules are being undermined, and therefore the Washington Consensus is collapsing. The UN, the Security Council, it is collapsing. The UN itself, it is collapsing to a point where the hallowed halls I used to work in Geneva, they cannot even be able to put on some lights. People, the UN staff are told, please work from home because they cannot pay the bill in Palais des Nations in Geneva. So the system is collapsing under its own weight. It is collapsing. Again, there are matters. So I'm not so sure that we can now still call what happened in the 1945 a new economic order, because that order is rupturing. It is collapsing. It is true. It is collapsing. Even the WTO system, I said this the first day, it is actually collapsing. I think the legal question that you may want to ask is to say, and by the way, the AfCFTA has not been notified to the WTO. I know Tunisia sought to do so, and they withdrew that notification. It has not been notified, because if it is an Article 24 agreement, or that is trade in goods, and then Article 5 agreement, the trade and services aspect of the AfCFTA, we have to notify to the WTO. It has not been notified. But here is the legal question you may want to think about. If the AfCFTA, and indeed not only the AfCFTA, any free trade agreement elsewhere in the world, it is premised on the WTO rules, and the WTO rules are being undermined, how then would you accord legitimacy over such trade agreements? Not only the AfCFTA, all trade agreements in the world. Because, for example, there are rules on sanitary and phytosanitary measures. There are rules on technical barriers to trade. There are rules on trade-related investment measures that we discussed the first day. There are rules on import licensing. When you look at the AfCFTA agreement today, you're not going to find any chapter that covers trade-related investment measures. You're not going to find a chapter that covers import licensing, because by reference, it is understood that the WTO rules will apply in the context of the AfCFTA mutatis mutandis. Are we together? But now what happens when the rules, the mother treaty, the WTO agreement, begin to falter, and nobody actually, or most the bigger countries, no longer go in accordance with those particular rules? What do I mean? Countries like, for example, the United States, the good thing is with the US, it's all in public. I think others in Europe, they hide, but they're doing the same thing. India is doing the same thing. China is doing the same thing. Indonesia, they even had a case at the WTO where they prohibited exports. They put export prohibitions, which are not allowed at the WTO, but Indonesia put an export prohibition of nickel. And a case was lodged at the WTO, but because there's no appellate body, and they lost in the first instance, they lost the case. But because there's no appellate body, they still continue to do their own thing. So meaning you can have rules, but because the system is broken, the rules now are unenforceable. I hope you can understand the predicament that the global trade is currently in. In fact, countries like China and the US, they're creating what they call, I think they call it a trade commission, something like that, where they will now bilaterally solve their issues. So the question is, where is the WTO? Even China is not following the WTO. I don't want you to think that it's a US thing. No, even they are dealing with these matters on a bilateral basis. In fact, they are breaching their rules under the WTO. So anyway, that's a different issue. So I think by talking about the question that my brother raised concerning DRC, so the protocol on women and youth seeks to achieve precisely that, to make sure that we have the small and medium enterprises trade across borders. Also, we have the protocol on digital trade. It has rules in there that also will allow for different producers of whether it be content, whatever it is, to be education institutions to be able to export their products across borders. I think that this digital trade protocol holds a huge promise for the small and medium enterprises, because like most of the small parcels that are exported normally is by small companies. So some of the things that we are working on is to make sure that even the trade documents are in local languages for people to be able to export their products across borders. But still, it will take some time. I don't want to say that tomorrow it's going to happen and then we are all happy. I think it will take a bit of some time for governments to understand what we are trying to do. So where I work, I have a division that reports to me on women and youth in trade. So that's exactly what we are trying to do. Because my conviction is we have small and medium enterprises, and therefore we need to make the instruments work for those. The other question that was asked, Abuja Treaty, we'll talk about it today. We'll talk about it, so if you don't mind, just hold on to that. It's going to be a very interesting one. Yeah, it's going to be a very interesting one. The other one, the ARIPO issue, it's a tough one because this issue has some politics in it. Who asked about ARIPO again? Yes, please. So it has some politics in it. No. I'm telling you that first, the ARIPO protocol, in terms of what we call the level of ambition, it is very low. Because them negotiating that protocol, there were other voices behind who made sure that that protocol is of a lower level of ambition. But what you have under the AfCFTA, the level of ambition is very high. So today we have a problem whereby ARIPO and OAPI, as intellectual property institutions, they feel threatened by the introduction of the AfCFTA protocol on intellectual property rights. So, now people are beginning to, some of them is jobs and all that, and so there's a lot of, and I asked the question to say, but tell me, wouldn't it be good for producers of the intellectual property rights, for example, to have one registration, and they designate the registration, whether it's patents or whatever, and then it applies according to the jurisdictions to which they have designated that registration. And they do it once instead of going to individual countries or going to ARIPO, going to OAPI and all that. You see what I mean? The efficiency of doing it. So, but I don't think that we are there yet, so there's still a bit of a pushback. The issue here is ARIPO is not the AU institution. OAPI is not. These are independent international organizations. This is where the question of member states having to figure out, what do you want? What is the most efficient? Because you can't have this duplication of institutions the way we are doing. So there's a lot of these duplications of institutions. So according to me, there needs to be a different approach. And then the CET issue, and the economic disparity, I think, countries are at different levels of growth, and it's a legitimate question. That's why in the AfCFTA we have faced, let's say, the level of liberalization. It is timed. Developing countries, I think they have 8 years, and LDCs 10 years. So there are a bit of some flexibility for the LDCs, but we know those flexibilities don't really work. It's about how, for example, Ethiopia is a least developed country, but the way they are coming up, I think that they are doing some things right. if you see how that is going. So we can have a conversation around that, but it's difficult. As someone said, actually it was His Excellency, the President of Rwanda. He said this idea of talking about, we call it special and differential treatment. He says, we cannot be asking to be given a special dispensation because we are poorer than others. He says we are all dwarves, only that some dwarves are a little bit taller, but we are all dwarves, economically speaking. So, and what that meant is you cannot take the principles we use at the WTO where you compare Lesotho to the United States, and you say, can Lesotho take the same obligations as the United States? Certainly not. And therefore we need a special treatment, a special dispensation. But if you come to the continent, can the same principle apply? Now that's where a country like Tanzania is a least developed country. But if you look at the level of productivity compared to some of the developing countries in East Africa, Tanzania is a little bit ahead. You see what I mean? At least commercially speaking. So that's the point. Let me quickly run through the slides. Please allow me. I will not go through everything that we have there, so I will speak to the issue of the institutional design of the AfCFTA. Unfortunately, that's slide 10 if you are following the slides. So, the AfCFTA has a couple of prescribed institutions, and the way it works is that we report to all work on the AfCFTA gets reported to the Assembly of Heads of States and Government. And there's some things that I would like to highlight. We report to, so for example, if we negotiate a trade agreement, it goes through some committees. So the institutional structure is such that we have technical committees. These technical committees are made up of technical experts from the member states. Let's say it's a negotiation on intellectual property rights. Experts, IP experts from individual countries will gather around either to negotiate or to deliberate on a given IP issue. The outcome of that meeting, so that's part of the institutional framework. The outcome of that meeting, it will be taken to the Committee of the Senior Trade Officials. We call it STOs. The Committee of the Senior Trade Officials reviews all the work from the technical committees. It can take back part of the work back to the committees for further consideration. So it's like a clearinghouse. Or it can forward the outcome of the work of the committees, and it can even provide its own inputs, and then it will go to the Council of Ministers. Are we together? The Council of Ministers will now look into whatever matters there are, and it has certain powers. It can consider whatever has been tabled to it and make recommendations to the Assembly of Heads of States and Government of the African Union. However, it also has the mandate to issue directives. It can make directives. Also, it can issue regulations. Are we together? So it is empowered to make directives and also come up with regulations. I hope you can now see there's a little distinction between other organs of the African Union, in the sense that because trade is that sensitive, and you're talking about economic matters, these economic matters, you cannot leave them to the whims of politicians. Meaning some decisions cannot be decisions that are made on the basis of politics because they are that technical. For example, we had the Council of Ministers this past July in Abuja, Nigeria. And they adopted the regulation on women and youth in trade that allows for simplified trade regime and what have you. And that process terminates there. So meaning the Council of Ministers, it is also a rule-making body in that sense. And once that regulation has been adopted, or maybe let's say there's a directive that has been adopted by the Council of Ministers, it will be reported to the Assembly for noting. Because it is within the powers of the Council of Ministers to make those decisions. However, if, for example, there is a treaty or a legal instrument that is being negotiated, let's say the protocol on intellectual property rights, only the Assembly can adopt that particular protocol, or the annexes to the protocol. Only the Assembly can adopt that particular protocol. Now, legal instruments that go to the Assembly, they must also go through what they call the African Union Specialized Technical Committee on Justice and Legal Affairs, STCJLA, to look into, actually not to look into, they undertake the legal scrubbing of the instruments that would have come from the Council of Ministers. So if you have an annex to a protocol, if you have a protocol, they have to go through that particular specialized technical committee of justice and legal affairs, on justice and legal affairs. Are we together? The people that participate in that are from the ministries of justice and the attorney general's offices. They are the ones now who look into the, who do the legal scrubbing. Are we together? That's why the other day I was saying, okay, let me not say what's in my head. Because they will say I'm not African enough. I'm very worried about my reputation here to my African brothers and sisters. I'm joking. That committee, it is made up of member states, right? It's member states. Now, these are individuals. They are filters, if you will. They represent their states not only in the AfCFTA, they also represent their states in COMESA, they represent their states in SADC, they represent their states in ECOWAS, in IGAD, in ECAS, all these different regional economic communities. And whenever time they have engagements under those particular frameworks, the regional economic communities, they're supposed to do the same thing, isn't it? So if that thesis is correct, does anybody here come from the Ministry of Justice? From Justice, right? I think I've met you. I don't know where, but I think I did. So the question is, how would Egypt have instruments under COMESA that are inconsistent with instruments under the AfCFTA if the same ministry is supposed to be doing the assessment of the consistency of its obligation? And this is very selfish. You say, I am Egypt, I made this commitment under the AfCFTA, I made this commitment under COMESA, under this, under that. How come then they would arise a question of inconsistencies or conflicts of laws? You see the point? Because it's the same people, or at least it's the same ministry. That's something that, and believe me, okay, I will not say these things.
People who take care of like drafting or like reviewing COMESA duties became other people who work on the file of AfCFTA. That's why it's like sometimes issue of governance, and sometimes else issue of like not figuring out the conflict or the inconsistency between both until a dispute or issue arise out of that.
And by the way, and you're right. For me, I normally put the biggest blame on the legal officers in the Ministry of Trade, because it's not the job of guys in the Attorney General to do the technical assessment of the legal consistency of the different treaties. They wouldn't know anyway. It is the legal minds in the ministries of trade that are supposed to technically filter and say, no, this is not, exactly. And then when it goes to the Attorney Generals, you look into the broad matters of law and what have you, and then it goes to the Parliament. Are we together? So, we do have a very unique, and some people, they oversimplify these things. They say, no, it's political. No, the minister said we should do it. We should pass it quickly. The minister said we should pass it quickly. She says yes. You see what I mean? And then when it comes to implementation, and then you ask me, how come enforcement? How can you enforce conflictual matters? My fear about our legal regime in Africa is that, let me put it this way. I'll flip it. I believe the reason why we don't have as many disputes in trade, it is because we don't trade amongst ourselves. I'll repeat that. I believe the reason why we don't have as many trade disputes amongst ourselves in the continent, it is because we don't trade with each other. Most of our products are coming from outside the continent. Imagine if indeed all of us, we have so many factories and services suppliers, and we begin to supply each other, and then we begin to find their inconsistencies in how a given country applies its laws, or indeed that there are indeed conflicts in terms of the application of the law. I dread the day we have the capacity to trade with each other effectively, because it's going to be a mess. That is why I mentioned, hopefully, I think yesterday, that we are trying to, I didn't mention it here. I mentioned it elsewhere. We are having a work stream where four things, it's four, I believe. We have created a mechanism where the AfCFTA Secretariat sits with all the regional economic communities secretariats. And we are going to start a process of undertaking an analysis of the relationships between the AfCFTA legal instruments and the legal instruments at the REC level, with the objective to identify areas, four things. One, areas where there are conflicts between the rules under the AfCFTA and the rules under the REC treaties. Number two, to identify areas where there are inconsistencies between the AfCFTA legal instruments and the REC's legal instruments. Number three, to assess with a view to implementing that particular principle of having RECs as the building blocks, to assess areas where RECs are far more advanced than the AfCFTA. And then number four, to actually also identify areas where the AfCFTA is far much more advanced than the RECs. The whole idea is to deal with the question of the inconsistencies and conflicts so that we help our member states, and I came up with this idea to say we need to have a evidence-based mechanism whereby we can identify these inconsistencies and conflicts and go back to the member states to say, you gotta clean up your house in this and that and that. You see the point? Then the other part, the other two elements, the idea is to make sure that whatever the RECs do, if it's in an area where the AfCFTA is far much more advanced in terms of its rules than the RECs, they use the AfCFTA rules. You see the point? Also, within the context of the AfCFTA, we do the same thing. I have 2 minutes, right? So that's an important issue, but otherwise, we do have that particular structure. We also have the dispute settlement body as part of the institutions of the AfCFTA. It's a copy and paste of the WTO dispute settlement. Copy and paste. Okay, I'll not say much, but I think I had told you I was not happy with the copy and paste because I don't think it's representative of our realities in the continent, and those who developed that text did not consider some of the proposals. I tried to share with them the proposals we had. I think there was no appetite to include them as part of our dispute settlement system. So, but, and by the way, the key thing about it is that our dispute settlement system under the AfCFTA, it's state to state. Private parties don't have access to the AfCFTA dispute settlement. It's state to state. Now, the problem is, I was telling my brother here, it's in the area of investment. In the area of investment, Egypt, Morocco, Mauritius, Rwanda, I believe Tunisia, they are pushing for the investor-state dispute settlement under the protocol on investment. They are pushing for that. There are other members who want it, but they are quiet, so I know them. But those are the countries on record who are pushing for investor-state dispute settlement. And it's a very tough issue, and that's why the negotiations on the annex to the protocol on investment are not yet done because of that issue. In the meantime, as you know, most of the advanced countries are moving, including the United States for that matter, including Europe, they are moving away from the investor-state dispute settlement. You know that the companies that invest in our countries, they are screwing us up in some instances. The investment cases. You see the point? What I understood is that, at least for the US, they consider it as a matter of sovereignty, that no arbitral body that is not part of the US court system can determine the fate of the US. And I thought that the same idea should apply. So now imagine if, I don't know, you know, okay, let me not say this. I really don't know the rationale. Of course, countries have the rationale. For example, Egypt and Morocco, they believe they're going to be exporters of investment into the continent. And they need that. So you could say that is justified from that perspective. At the same time, we know that such an approach will actually work mostly in favor of non-African foreign investors than the Egyptian or the Moroccan investors. The other reason why these countries are pushing for this, they want to host the exit, they want to establish this arbitral body in the continent. So they are bidding to host this exit body at the expense of, I'm sorry, okay, let me not say, at the expense of us being exposed to investor-state dispute settlement mechanisms. Again, as you know, once you have that, Europe has over 400 billion worth of investment in the continent. So that system, who is it going to work for? Certainly, Egypt and all these other countries are not going to put $400 billion worth of investment. So it's going to work for Europe. It's working for them now. But Europe is moving away from this thing. China has moved away from this thing. Everybody is actually, today under the ancestral, I can't remember what is working group 4 or 5, there is engagements on this where countries are beginning to, to toe the line of the United States to say, let's do away with the investor-state dispute settlement. So ladies and gentlemen, that's basically, we can say much about this framework. There are many other issues that are political because under the assembly, for a matter to go to the Assembly of Heads of States, and government, it first has to go through the Committee of the Permanent Representatives. These are our ambassadors based in Addis. Then it goes to the Executive Council. That is the Ministers of Foreign Affairs. We were in Addis, I was in Addis last week. It has to go through that then, meaning the Council of Ministers would have its own issues. Its issues would go to the Executive Council. Other matters that are institutional to the AfCFTA Secretariat, they will have to go through the Permanent Representative Committee, the budgets and what have you. So the AfCFTA Secretariat, it is also part of the institutions of the AfCFTA. And the AfCFTA Secretariat has its own legal personality. Let me stop there, he will kill me.
Thank you very much.
You asked a lot of questions.
Okay, we give him flowers at break time already. We come back after 10 minutes, so which means we come back.
Or let me put it in a different sense. You have those institutions of the African Union, and there is a decision-making procedure and process. And the Secretariat being part of the institutional architecture of the AfCFTA, and the AfCFTA here refers to a free trade area, a free trade area. The rules create a free trade area. That's what the AfCFTA is. Then you have the AfCFTA Secretariat. We, the public servants working for the AfCFTA Secretariat. The AfCFTA Secretariat, which is the organ of the African Union, similar to how this court is an organ of the African Union. The distinction here is that the AfCFTA is an autonomous organ of the African Union, as per the dictates of the treaty. It means similar to the African Union Commission. The AfCFTA Secretariat has an independent legal personality. If you will, the AfCFTA in its own right can be deposited with the Secretary General of the United Nations as an intergovernmental institution. The AfCFTA Secretariat can enter into contracts, similar to how the African Union Commission can enter into contracts, by virtue of having the operational autonomy and also having this legal personality. There are only two things of which it is not independent from the African Union system, and that is matters on human resources and matters on budget. For those, it has to go through all processes that all organs of the African Union go through, meaning it has to go through the ambassadors committee. It's called Permanent Representatives Committee, and it has to go through the Executive Council on those matters. That is matters that have to do with human resources, as well as matters to do with budget. So that's a very important issue to raise. I wanted to be controversial, but now I've forgotten what controversy I wanted to raise concerning the status of the AfCFTA. Anyway, maybe it will come. There are other institutions we have you've been asking the questions around how do we ensure that there's enforceability. Under the AfCFTA, the member states agreed to create the national implementation committees. And these committees are supposed to advance the implementation of the AfCFTA at the national level, hence why this question of the assessment. Yeah, okay. So we have these national implementation committees so that, again, through the assessments, we will give them the outcomes of the assessments, and then they can see how to reform, how to sequence their reforms. We also have an arrangement with Afrexim called Pan-African Payment and Settlement System, PAPS. The rationale behind PAPS is to try to undo the system that was created in 1945. Because today, if you want to export your products to another country in Africa, if you are from Zambia, you have to change your kwachas into euros or into dollars. And then the receiving country also has to change into their receiving currency. That is why if you were to export a product worth $20 using your local currency, you will have to add 40 or more dollars to that. So you end up paying more than $60, yet the value of the product is $20. Let me sit on that a bit. One of the reasons why Africa cannot trade with itself, it is because of the cost of finance. The continent loses, and this is conservative figure, on an annual basis, it loses $5 billion in FX exchanges. Converting your currency into the dollar or any other global currencies, reserve currencies. $5 billion. Please think about that a bit. Just let it sink a bit. Are you saying if you are selling your product here in Tanzania to Lesotho, you have to convert the Tanzanian shillings into dollars? Yes, you have to. How does that happen? You go to the bank. The bank is an intermediary between you and the other person who is going to receive the product in Lesotho. But the bank will now take your money and then convert it into US dollars. But that process, it is owned by a US company based in Brussels called SWIFT. SWIFT takes its own fees. There's also Citibank in the US. It also takes its own fees out of that. Meaning, this $5 billion, it is going to SWIFT and these correspondent banks in Europe and in the US. So imagine if you're an American. I'm told there's someone from the US. Hello? No? There you are. There they are. Yeah. Yeah, there they are. So, you see how unfair the system is, because if you have dollars, which currency do you have to change your dollars into? None. You get the point? So you have to pay $5 billion to trade. Look, you're not even trading with US or with Europe or with China. Amongst yourselves, the system is such that your currencies are not convertible. So we sat with the Afrexim Bank to say, how can we deal with this issue? And we said, let's find a way to reduce the costs of currency convertibility. And we came up with this Pan-African payment and settlement system. The truth of the matter is that Nobody would allow you to come up with, I like telling the truth, at least the way I understand the truth. You know, it's my own truth, it may not be true to you. There is no way the United States could allow a system that is still not dollar denominated. So the way PAPS works, it still has a dollar exchange behind, though the fees now have come drastically low. Are we together? So this is the reality of our times. Your currency, in terms of its functionality and operationalization, you have to check with the International Monetary Fund. Hello? You have your central bank. Do you understand that the central banks are not subject to your government? I hope you understand that. Maybe I shouldn't go there. Because I feel like I'm not poisoning you. I hope I'm not. The central bank, as you know, is it part of the arms of the state, any arms of the three arms of the state? Does it fall under the executive? Does it fall under the judiciary? Does it fall under the legislature? Where does it fall? Does the central bank determine the rates? Hello? No, it does. The rates as to your currency. It sets the monetary policy, no? Hello? So it sets the monetary policy, but it is not subject to the legislature, not subject to the executive. So, to who exactly are the central banks subject to? So, I'm going to leave it there. Think about it, research about it. If he invites me next year, we'll meet again and you'll give me the answer. The only thing I will tell you is that it is within the construct of the architecture that was created in 1945. When they say, oh no, the Egyptian dollar against the US dollar against the euro, oh no, things is not performing well. Then for Egypt now, it's a problem because of the Strait of Hormuz challenges. Because Egypt, the economy survives on the incoming imports. And it's a dollar-denominated economy in a sense. They can't survive. So the moment the prices go high, the economy always suffers significantly. There are countries like that have huge exposure to the dollar. The moment the value goes up, they always have a problem, depending on wherever they stand in the spectrum of buying goods and services that come into Egypt. It's not only Egypt, it's other countries as well. The South African rand, for example. It's a system. Why are we describing these systems? Because they are founded in the law. They are founded in the law. So the Pan-African payment and settlement system was precisely designed to at least reduce the cost of trade for Africa, which is quite unfair for Africa. So when people say, oh no, Africa, people are not making decisions. Oh, we are not making decisions? Do we have the withal to make the decisions ourselves? The sovereignty to make monetary policy, do we have that sovereignty to come up with our own decisions? When the US, a Federal Reserve, when they're about to issue a statement as to the health of the American economy, all the central banks in the world, including ours, will be the first one to be watching the TV to understand what's going on, so that they can inform their own monetary policy. Remember, it's a three-legged system: trade policy, monetary policy, and and finance. They are interworking. So we are trying. I heard yesterday our colleague Guy was talking about Africa has now a monetary. Been a dream we had for many years to have an African monetary system. And right now, like I said, we need to be very patient. It's a shell in the sense that the framework is there. We are trying to activate it, but hopefully down the line would be in a positive effect, and that would be at a point when the world changes drastically. But we don't have control over this matter. Yes, sir.
Question just raised on my mind now. Why Gulf countries, although they rely strongly on oil and and dollars, because it's like all oil is priced by dollar, they don't have such kind of fluctuation and effect by the monetary policies of USA and worldwide. What I want to say, like the currencies of Gulf area don't get affected that hard as our currencies by change of any monetary policies, like dollar price or any other prices, and the interest rate of American banks.
I'm just a lawyer, so when I don't have an answer, I will admit to say, I don't know. And I don't. But I think that the way when I listen to the economists, first, of course, for those economists are dollar priced. They fetch the oil using the dollars. And not only that, they also have substantial trillions worth of dollars in reserves relative to any one of us. Literally, they have trillions worth. So they have the capability to provide economic buffer to the economy. So it's difficult for you to see them being affected because they have the money. So that's the only way, the way I would understand it. You look at a country like you look at the Emiratis, you look at the Qataris, Kuwait. Those guys, in terms of their reserves, it's in trillions of dollars. That is why if you look at the deals between the United States and those countries, and you look at the Emiratis, the level of investment they have promised to make in the US, it's in trillions. You're like, you mean you're going to have trillion worth of investment, a small country like that? So how much do you have if you are able to invest such trillions of dollars? So those guys they have huge dollar reserves. And also, if you look at the Emiratis, they're accumulating a lot of gold as well. Unlike most of us, we have a few bars of gold. They're accumulating significant amount of gold. So I'm not an economist, but my understanding is that they have huge reserves in dollars. And therefore, they're viable economies in that sense. They are turning the ocean into like, they have this huge, of course we have them in Egypt, but look at their desalination plants to turn the seawater into drinkable water. And you know that's very expensive. But they have money to actually put money there. They don't know where to throw their money. So those are the institutions that we are having. And there are other things. I'll speak about this last one, and there are other things. Now, these are initiatives, not institutions. Even PAPS is not an institution, it's an initiative. We also have the adjustment fund. And this is a fund that has been put together by the AfCFTA Bank and ourselves. Of course, the bank has gotten the money to make sure that as process of liberalization ensues and it goes forward, of course, countries are going to lose revenue. Somebody earlier asked about what about countries that are indigent, countries that do not have a certain level of economic power. What happens to them? If you implement these measures and then you were to lose funding, the adjustment fund, you can go and borrow money there. So there's a mechanism that has been put in place to ensure that the shocks may come as a result of the liberalization do not run deep when it comes to the countries affected. Okay. There's one thing I wanted to mention. Yes, please.
Thank you, Esa. My comment on Pan-African Payment and Settlement System, PAPSI, is that some of the African countries have tried their level best to make sure that they implement this one. For instance, for the case of Zambia, after President Hakainde Hichilema tried to insist that HHS tried to insist that for the case of trade in Zambia, all mining sector, mining sector and other trade business should be done using local currency, that is Zambian kwacha. And we have seen that Zambian kwacha has, its value has raised against the US dollars. And the business has grown to the point that Zambians are experiencing benefit from that particular production, particularly in mining and others. And this one has impact in Zambian economy, because you can find that Zambian kwacha has got value from 22 to 16. So I think other countries like Tanzania can copy that one to at least make the development be accessed. Yeah.
No, thank you very much for that. Again, not being an economist, I don't want to burst your bubble, but for an African country to come to a point where it takes a certain decision on its monetary policy, there are checks and balances that they must meet. Now, it may as well be that, and I don't know, in the case of Zambia, it may as well be that Zambia decided not to listen to the IMF and adopt its own policy. It may as well be that. Majority of the times is that anything that has to do with your currency and the movement of the rates, it may not be implemented if it's not endorsed by the IMF. And the reason being, have you heard the saying that it is he who pays the piper who dictates the tune? Have you ever owed somebody money? Have you ever owed somebody? And you see that person, you know, it's so difficult. You even want to go a different direction. You know what I mean? So most of us, because we are indebted to multilateral institutions, AFDB. They say it's an African bank, but if you look at the shareholder structure, it's different. So we are indebted to all these different institutions, right? What is the price of being indebted? Isn't it that there are conditions you must meet? So your monetary policy only functions to an extent that you comply with the conditions of your debtors. So if this that you are describing, it's a policy that is consistent with the condition placed upon you, then that's fine. It means you have a certain modicum of sovereignty to make certain monetary decisions, monetary policy decisions. Majority of the times, it's not the case. Majority of the times, there would be a proclamation from Washington that goes to your central bank to say, this is how this thing should work. the countries in Africa with minerals are even much more prone to this sort of proclamations coming down from heaven, if you will. Because there is competition over minerals now. You have Europe competing for African minerals. You have China competing. You have the United States competing mostly. Those three, mostly. That mineral competition is dictating a lot of things. And everybody is getting individual countries to be more indebted to them, because the more indebted you are, the more you have to subscribe to the conditions that they lay out. So all I will do is simply go to look into your level of indebtedness, and I will know who's making your policies. How about that? I know we can take it offline, but my own country, our own monetary policy, I'm talking about my own. I know how the monetary policy is set. Yes, we are pegged to the South African rand. Other aspects of the economy, come on, we know. Many years ago, a country like Kenya, it was one of the least indebted countries during President Kibaki's time. And Kenya had the sovereignty to make its own decisions until indebted. Are we together? That is why, anybody from Kenya here? Yeah. What happened when you began to scrape off the subsidies to the fuel? They had a problem because the prices of, so who told Kenya to say, no, do away with the subsidies? Was it a sovereign decision? Come on. You see how you may be free in your mind, but your system is not free. All right? So these are the realities. That's why I've been trying to say, and I say this message all the time. When we study international economic law, we are taught in sort of like it's a divisible subject matter. So you will be taught trade policy. There's an expert on trade policy. What trade policy? There's an expert on investment. What investment? There's an expert on monetary policy. As if these things are not one and the same thing. They are one and the same thing. Isn't it that when a trader wants to export its product to the other side of the border, they have to look into the rate, the currency rates? Isn't that monetary policy? Come on. It's one and the same thing. So it's a very good intervention. That's making us go elsewhere. But I think for us in the continent, it is important that we know where we stand in as far as the international systems are concerned. Can we talk about what my sister raised concerning the Abuja Treaty? And I'm hoping we'll have a... Oh, there's a question. Sure. So there's two questions.
Bon, c'est juste pour enrichir ma question parce que ça n'a pas été bien répondu. Pourquoi pas au niveau de l'Union africaine, oui, pourquoi pas au niveau de l'Union africaine de ne pas avoir une politique d'appuyer les partenariats les partenariats au niveau régional entre les petits entrepreneurs qui ont des entreprises de production, de transformation et de production de produits locaux de manière frontalière. Maintenant, est-ce que si la politique est déjà là, est-ce qu'il y a un instrument juridique qui existe? Oui, bien sûr. Chaque pays est souverain et a sa politique d'encadrer les entrepreneurs à l'interne du pays. Maintenant, est-ce qu'au niveau régional, est-ce qu'il y a une politique qui existe? Par exemple, moi, je suis un entrepreneur au niveau de la RDC. Oui, en tant que le frère et sœurs, on collabore avec d'autres pays voisins, mais de manière vraiment très professionnelle, dans le cadre des échanges commerciaux. Est-ce que vraiment il y a une politique qui existe pour nous appuyer, nous les entrepreneurs, au niveau local et régional? Merci.
Yes, sorry, I understand what you're saying. The issue of the continent, at least the AfCFTA, we only have the protocol on women in trade, women and youth in trade. That's what we have. Under that protocol, we have a regulation that has been adopted on what we call simplified trade regime. What that regulation does, for example, as you know, before you had these challenges between Rwanda and DRC, I don't know whether this policy is still operational, but Rwanda and DRC had a simplified trade regime where the Rwandese small-scale traders have an ID card and they can cross over from Kigali into the DRC. And the DRC traders can cross into Kigali to export their products. And that is what we call simplified trade regime. Why is it called simplified trade regime? Because these traders do not have to comply with the same regulations that big companies are bound to comply with. And that's a policy we have in the EAC. We have the similar policy in COMESA. Now, we in the AfCFTA, we are saying those policies, using that particular principle, that the regional economic communities are the building blocks of the AfCFTA. Let's take the simplified trade regimes of the different regional economic communities and lock them into the AfCFTA. So this is what we have done through this regulation, meaning we are transforming the regional law into continental law. This is what we have just done this July when the Council of Ministers said. So is that a continental policy on small and medium enterprises? Yes, in as far as simplifying their trade between countries across borders, between themselves, across borders. So in that sense, yes. The AfCFTA does not extend as far as the finance policies of countries. We don't have a mandate. We don't go into that level. However, in the protocol on women and youth, countries have undertaken obligations to ensure access to finance by women and youth. And the work that we are doing now with a very small team that works with me is to begin to bring together some commercial banks so that, for example, if you take Access Bank in Kenya, not Access Bank, sorry, Equity Bank. Access Bank is Nigeria. Equity Bank. They have proven that it is possible to offer loans to small-scale traders. It's a bank for small-scale traders. And we are beginning to take that model and say, how can we bring all the other commercial banks to be in a position to emulate the successes by Equity Bank? So this is what we're trying to do. And we plan to run the boot camp where we'll have the small and medium enterprises and the banks. And they're able to show us the conditions that apply for small and medium traders to access their funding. So there's operational level, and then there's the legal part, which is the regulation on simplified trade regime. So in that sense, this is the much that we can do. And we are cognizant of the fact that for trade to happen in Africa, rules alone. There are different schools of thought. There are people who believe the Secretariat should just be the administrator of rules. And I am not one of those. Yes, we have rules, but I tell people rules alone are not enough. We've been taught to focus on rules. That's what the WTO tells us. Compliance, compliance. I said, no, it cannot be. In our continent, we need to also have productive capacities. Let's ensure that the funders are around and the people that we are beginning to work with now to make sure that they can avail funding for the small and medium enterprises. One of the initiatives that we will be putting in the couple of months to come is to also have a portal, a dashboard, where a small and medium enterprise can go into that dashboard and they click, they look at the bank in their own country and they see the conditions that apply when it comes to access to finance. So there's a couple of things that we are trying to do in that direction. I apologize I could not answer you specifically initially. Yes, please, my brother.
Yes, Professor. I was just beefing up your earlier point. I just wanted to give two examples that come to mind. For example, the conflict in the DRC. If you remember, when the president of the DRC went to sign with an agreement with the president of the USA, for the USA to provide security and security and military presence in the DRC, there was an agreement signed that the DRC will allow American companies to come into the DRC to get rare earth minerals and other minerals. So you can see that if this is given as a condition, currently I think it's Blackwater that has its presence there, helping the DRC security fight the M23. But the condition given by the US government to deploy security resources was that the DRC allows American companies come in and access their vast minerals. In Uganda, currently the president has been against export of raw materials. And the reality, like you say, it's easier said than done. When you say you don't want your raw materials exported to the West and you want them, you want value addition, it's not as easy as you can imagine. Uganda today is the largest exporter of coffee. It just overtook Ethiopia. But a kilo of coffee raw beans exported to the West ranges between $3 to $8. This same kilo of coffee, while once processed in Europe and made into the coffee that we consume, will fetch you $25 in the same kilo. So there's been that move, but we can see a drastic pushback by the same companies who come and buy the raw beans from Uganda, saying, no, we don't want made in Uganda coffee in the shelves of supermarkets in London, in France, Italy, and elsewhere. So it's easier said than done. I was just agreeing with your point and giving examples that we're not as sovereign as we think, and even when you might want to do things the right way, or things that benefit you as a continent, it's not as easy as it might seem.
Somebody who agrees with me. So, no, it's a reality, it's a context, and what I'm trying to do is say there's a law, but there is a reality. And the law is born out of these realities. And as you rightly said, I'll say this and then we move on and talk about Abuja Treaty. Several countries, including emerging developing countries. Those, if to say this is about the West, them against us, no, you'll be mistaken. A country like Singapore, Malaysia, India, China, you know that they have raw materials strategy? I want to say that again. Those countries, just like the European Union, if you go on your website right now, the EU has raw material strategy. And in that strategy, Africa is there to say, this is where we're going to get the raw materials. So somebody has sat down, thought through, and passed this strategy through their legal systems as a matter of law, that a place where we are supposed to get the raw materials is in Africa. So you think that now when you come and say, no, I want value addition, desirable as that is, you think that it will be that easy for you? Where are you going to get the financing in the first place to invest in steel smelter? Where are you going to get that? Are we together? So it's a matter that countries, it's not a proclamation because the president said, oh, no, we are now going to add value to our products. Oh, really? In some countries, it's a matter of law. I see in DRC, they have come up with this, I don't know whether it's a matter of law or it was just a presidential proclamation, where now China is having a problem in terms of certain minerals because DRC said, unless you process from here, it's not going out. Right? Yes.
I wanted to put a rider to that. The EU has passed what they call the Critical Materials Act. Yeah. But then those critical materials they're talking about, 90% they're referring to Africa. Yeah. Now, we tried to lobby against that in Brussels. And we had a lot of support from certain members of parliament, of good conscience, and of the Green Party and the left wing, until when there is what they call in Brussels the Critical Materials Week. During that Critical Materials Week, they invite ministers of mining and foreign affairs and so forth to Brussels. They pay them first class and feed them very well, and then they promise them, yeah. So before they went to Angola to sign that deal, which you are aware of, first they came to Brussels. By then I was working there. And then we had made a very big lobbying. When the Zambian minister, I come from Zambia, the Zambian minister of mines took the podium, he said, you know what, we don't want to waste time. EU, give us your euros and give you the minerals, and all people laughed in my face. To give you an example of how much we are vulnerable and we are the biggest enemy of our own progress. Yeah, because we don't take time to do what is right and the civil society is cut out. Now, my question to you is, from your experience, how can we ensure that we give enough room to the civil society to take part in the African development architecture? Because in many countries, the civil society has proven very right, and I go back like a broken record to the influence of Robert Schuman to the EU as we know it today. Robert Schuman was not an influential politician. He was an ordinary person, but who won trust among the EU actors and influenced to see the EU where it is today. In the beginning, he looked like a madman, but today he's seen as a hero. So how can we do that? Like influencing a civil society like yourself and myself. Thank you.
It's a good question, certainly. Like I said, maybe it's my weakness, right? So you have folks who believe in doing and getting things done right now. Let's solve this problem now. The economic interests. I don't know whether I don't know. Have you heard when countries say, we are going to deploy our armies to this particular country or that country, or we are going to deploy the mercenaries they do, this country or that country, in the name of safeguarding our national economic interest. So there are lines that you cannot cross from their perspective. Because if you do, it means that you are decimating the economic basis of those countries. This is not free lunch. It's not benevolence. It's not. Like I said, I believe that it's gradual. It's gradualism. Being able to carry out your mandate in a gradual manner. There are things that I will not say, some examples that I will not give you. Like I said, if You want to lose your life? Be my guest. Go and be radical. Not that you are radical. So they call it radical. It's not radical because it's asserting your economic rights as the owners of the raw materials. If you look at most of our countries, and I laugh, because I feel like we are being made fun of as the continent. I laugh because you hear somebody saying, my country from today onwards, we are not going to allow export of raw materials. Okay. Then I'm wondering, what do you mean? Because your country has entered into concessional arrangements with some mining companies from wherever else in the world, whether it be China, whether it be Australia, wherever, Canada, all these different countries. And you've already sold the mining rights for the coming 100 years. Hello? You've sold the mining rights for the coming 100 years. What do you mean that you want to add value when you've already sold the mining rights for you know something that they call futures market? In the stock exchange? Futures market. Those that are trading in the futures market, it is because they have those concessions that would run for 100 and so many years. And they keep on selling rights to this investor. Another one comes with a better deal. And before you know it, the price of that commodity, it's so high. I'm surprised that we're discussing these matters. I wanted to talk about the AfCFTA. But the AfCFTA, as it is, the moment you talk about what is tradable, these are the constraints. Because if you want to add value to your raw materials, you already don't own them because they are owned by a company to which you have sold the rights. Let me give you an example. When I was working here, I had a colleague from Zambia, and I was after this, so that you understand. So I'm saying there's the law of how the world really works. He's from Zambia, right? I was working with him in finance. He gets his gratuity, and he says, I want to invest in copper. He's from Zambia. Remember, Zambia is one of the biggest copper producing countries. So he goes to Zambia, and he had somebody who was willing to buy copper from me. In fact, this individual said, please get me copper. So, you're from Zambia, he knew some people, he used to work in the copper belt. He said, okay. So he gets his gratuities, I'm going to buy this thing. He got told, there is no copper to sell. This copper is sold for the next 20 years before it's mined. Hello, Madam Abuja Treaty. you get this is how markets work. Are we together? You wonder why these contracts between governments and mining companies are so secret. Because you're going to discover that a given mine, they do their assessments. I had an uncle who was a geologist. He passed on, God bless his soul. He was a geologist. So when he takes us through how these things work, that's when you'd understand why certain things are difficult. Because you've already, there are things I cannot say. But let's talk about it. It's getting a bit uncomfortable. Okay. Abuja Treaty. Abuja Treaty. Let me get my phone. If you could open the Abuja Treaty, I send it this to the group WhatsApp. If you don't mind, please open that document and let's go to Article 6. It's on page 21. Are we there? So, the treaty came before the AfCFTA, isn't it? So, I will read it out. Article 6, modalities for the establishment of the community. The community shall be established gradually in 6 stages of variable duration over a transitional period not exceeding 34 years. By the way, this treaty was ratified by African countries. Okay? That is clause 1. 2 says, at such stage, specific activities shall be assigned and implemented concurrently as follows. The first stage, strengthening of existing regional economic communities, and within a period not exceeding 5 years from the date of entry into force of this treaty, establishing economic communities in the region where they do not exist. So, first, there has to be the strengthening of existing economic communities. That's point number 1, right? That's what the provision is saying. And secondly, it says there has to be establishment of economic communities where they do not exist. Correct? Then let's go to a second stage. At the level of each regional economic community and within a period not exceeding 8 years, stabilizing tariff barriers and non-tariff barriers, customs duties, internal taxes existing at the date of entry into force of this treaty. There shall also be prepared and adopted studies to determine the timetable for gradual removal of tariff barriers and non-tariff barriers to regional and intra-community trade for the gradual harmonization of customs duties in relation to third states. They are saying, let's also carry out a study or studies to determine the basis on which we would further create a customs union, because the third stage refers to non-African countries. You strengthen the communities, and then you begin a process of trying to establish how can you create a continental customs union. How do you do that? You carry out the studies. Okay. Then, Roman numeral 2, strengthening of sectoral integration at the regional and continental levels in all areas of activity, particularly in the fields of trade, agriculture, money, and finance, transport and communications, industry, and energy. Did you see money and finance there? Okay. What does that refer to? What we discussed, right? Then you see there's also communications. You see that? You see that there's transport. Just think about what entails transport. Could it mean how we build our railways and roads, how we deal with our air transport? Could it mean that? Hello? Could it mean our regulations? Yes, to all of the above. Why? Because our transport standards and system are not controlled by ourselves. Okay. Then there's energy, even the energy itself. Roman numeral 3, coordination and harmonization of activities among existing and future economic communities. So, meaning even before the AfCFTA was created, there should have been coordination and harmonization in terms of what we have under the regional economic communities, the regulatory systems we have under the regs. Was that done? The answer is no. Third stage, at the level of each regional economic community and within a period not exceeding 10 years, establishment of a free trade area through the observance of the timeline for the gradual removal of tariff and non-tariff barriers to intra-community trade and establishment of a customs union by means of adopting a common external tariff. I want to read that again, because now this has a lot to do with the AfCFTA. They're saying the third stage, at the level of economic community and within the period not exceeding 10 years, establishment of a free trade area. So the regs were meant to establish FTAs, right? Hello? Are we together on that? Are we having the same reading? Yeah, they were supposed to establish the free trade areas. Then it goes on to say, of course, they have to also, secondly, they also have to establish customs union by, I beg your pardon, let me read that again. Third stage, at the level of regional economic community and within a period not exceeding 10 years, establishment of free trade area through the observance of the timetable for the gradual removal of tariff barriers and non-tariff barriers for intra-community trade, and the establishment of a customs union by means of adopting a common external tariff. Can we read that together with D? And then I'll come back to this. D says, the fourth stage, within a period not exceeding 2 years, coordination and harmonization of tariff and non-tariff systems among the various regional economic communities with a view to establishing customs union at the continental level. Let's talk. Where were the FTAs supposed to be created? At the REX level. Is there any intimation that there was supposed to be the creation of a continental FTA? Please, hang around with me. I know you're hungry. It's about lunch, I guess. Hello? Okay. Free trade areas, according to the WTO law, they are made up of two things. Under Article 24, you can have a free trade area in the area of trade in goods. Under Article 5, you can have an economic integration agreement in the area of trade in services. Are we together? The concept of customs union only applies in the area of goods, not services. I'll repeat that. The import duties applicable to physical products, that is what is attributed to a customs union. You create a union of countries that agree to apply same duties on products that come from non-African countries. Are we together? This is what it means. Physical goods. What this provision is talking about is physical goods. When it talks about free trade area, it is talking about goods, physical products. They are saying there's got to be the creation of free trade areas in regional economic communities across the continent. Meaning, these particular regional economic communities are supposed to open up their markets. Countries that are parties to those regional economic communities are supposed to first to open up the markets amongst themselves within that regional economic community. Now, if you are a member of the WTO, of course, Abuja Treaty came before WTO. if you are a member of the WTO, which then succeeded the Abuja Treaty, it means that you are supposed to reduce your tariffs on substantially all trade. Substantially all trade, like at the AfCFTA level, we've said it's above 97%. Most RECs, it's above 90%. Are we together? So the idea is let EAC reduce its own duties and create an EAC free trade area, not a customs union yet. And then they start having this free trade agreement within the EAC. Now the EAC also is compelled, the members of the EAC, they are compelled by this provision to also create the EAC customs union. Right? Are we together? And the EAC did that, no? COMESA, I beg your pardon, ECOWAS did that. There's ECOWAS customs union, and then there is the EAC customs union. Are we together? So we could say somehow, though I normally say the EAC, okay, I'll not say that here. So, no, I can say it. Yeah, you're not member states. This is supposed to be academic, isn't it? The EAC, the customs union, they have what they call the stay of application. So you just apply to say, we agreed to charge this tariff, all of us, but we want to be given some form of an exception. We can vary from the common external tariff. So they now have hundreds of products of which, these products being subject to these exceptions. You see, so it's no longer, the sanctity of a common external tariff has actually been undermined. Okay, that's what I wanted to say. So the EAC, let's say, forget what I said, they have created a customs union. ECOWAS has a customs union. So we could say that these regional economic communities are consistent with the provisions of Article 6 of Abuja Treaty. Are we together? What about SADC? Is SADC a customs union? No, it is a free trade area. Meaning the SADC member states have not met the conditions and commitments that they took under the Abuja Treaty. Talk of enforcement. Who enforces the Abuja Treaty? Because it entered into force. It entered into force. Are we together? So, the plan, or not the plan, the commitments of African countries was such that, one, create the FTA, where you don't have the regional economic communities, create them. Those regional economic communities must create the free trade area, free trade areas, meaning agreements on trade in goods. Are we together? You can see that nothing that speaks of them entering into economic integration agreements, agreements on trade. We're talking about trade. After you've created the FTA, create a customs, a regime by all countries in that regional economic community have exactly the same duty against non-participants to that customs union. And I want you to think about it in two terms. The first one is the simple one that we discussed, because it would have meant they create a common external tariff against non-African countries. I hope that is clear to you. Against China, against, I don't know, Norway, I don't know, against Venezuela, I don't know, Nicaragua, all these countries that are non-African. All of our member states, if the duty on this particular microphone is 20%, all of us must adopt 20%. Is that understood? Do you think that the same terms will apply to other African countries that are not members to that customs union? Let's assume the EAC institutes a common external tariff on the microphone at 20%. For non-EAC countries, the non-EAC countries would be made up of both non-African countries and African countries that are not members to the EAC. Are we together? I'm sure others are lost in the woods. They're thinking about the dance tonight. what this provision means, if a regional economic community establishes a common external tariff, meaning 20% duty applied on this mic, it means that it will not only apply on Nicaragua, a non-African country, it will also apply on Egypt, it will also apply on South Africa, because all those countries are not members of the EAC. Are we together? The same analogy applies to ECOWAS. Are we together? So this is how it is. FTA, first, create the regional economic community. 2, create free trade agreement. 3, create a customs union at the level of the regional economic community. The fourth area now is that you create a continental customs union. You cannot belong to 2 customs unions at the same time. Not unless the common external tariffs of those customs unions are exactly the same. But practically, it may be impossible for a country to belong to 2 customs unions at the time. So, what this provision is saying is to say, now you need to collapse all the customs unions into one continental customs union. Any question? Today they don't want to give us water. They don't want to give us water today.
My question is like, if or like when AfCFTA reach all its objectives, then there will be no use for all regional community REC economic, right? Answers right? But the only thing, because I was like keep looking about the differences, there is some sort of dispute resolutions exist in some REC, regional economic communities, such as COMESA, doesn't exist in FCT. So why AfCFTA is not inclusive or have all options for disputes, so we can say, okay, now we don't need any other economic community. Specifically, I'm talking about investors' ability to raise any claim or to raise dispute against host states, because I believe this is the most concern for any investor in other African country.
No, thanks. If you don't mind, and I'll come back to this question, because first I wanted us to look at the Abuja Treaty and then see how the Abuja Treaty relates to the AfCFTA now. Or vice versa, whichever way. Yeah, so if we finish this, then we can come to that question. So, it's the same member states. Oh, sure.
You talked about customs union in the EAC, and it's not good to have the spaghetti ball where Tanzania is in the EAC and it's also in the SADC. And we can see in the EAC, all the member states are also in other regional integration. And you say that the custom union, to work better, we have to be one. But you can see sometimes, allegedly, Tanzania can focus mostly in SADC rather than the EAC, because the SADC customs union is more favorable, so they are like forum shopping. So the custom union, honestly, I feel like it's just an illusion that we want to focus on, but in reality we choose what we want.
Oh, thanks for the question. What I said is, you can't belong to 2 customs unions at the time. And the right, to an extent that those customs unions are not symmetrically aligned in terms of the common external tariff. if you go to Article 24 of the World Trade Organization, it's not just a question of the duties. It is also what it calls other regulations of commerce, ORCs, other regulations of commerce. And because mostly people who follow the subject matter on international trade are economists, lawyers, they don't want anything to do with economics. I don't know, because you guys, you are terrible with numbers. So anything trade, we think numbers, and no, we don't want to touch it. I don't know why. But the lawyers should have done a better job at looking at the extent to which other regulations of commerce, as a matter of a commercial policy of a customs union, are also supposed to be treated symmetrically the way we are treating the duties themselves. So you'll find less of writings on the notion of the other regulations of commerce. The point I'm making is that it is perfectly possible for a country to belong to a customs union and belong to a free trade area. The similar way, Tanzania is party to the EAC, customs union, and it is also party to SADC, FTA. Tanzania, it is also party to the AfCFTA, FTA. You're from Kenya? Where? Yeah, Tanzanian, right. Kenya is also a member of, or rather a state party to the AfCFTA. Are we together? The rule that applies if you become a party to a customs union is you only have to have the similar common external tariff. So we expect Tanzania to have obligations under SADC. They should also be obligations that do not breach the EAC common external tariff. Otherwise, they will be liable under the different, under the EAC enforcement. Are we together? Yeah. So, what I wanted to say is that, I'm sorry. You know, sometimes I laugh because I just don't believe it. You know, I don't believe it. What I said to my brother here earlier on, it is the same governments that are making commitments under the Abuja Treaty, who are making commitments under the EAC, who are making commitments under the AfCFTA. Same governments. First, we can see they have not met their obligations under the Abuja Treaty. Who cares? I've never heard anyone within the African Union system systematically seeking to deal with this matter. I've never heard anybody. Never. Where we say, what has happened to the ratification, post-ratification implementation of the Abuja Treaty? What is true is that member states have missed the deadlines. Member states have not created the customs unions that they were supposed to create. Only a few have. And today, we don't have the Continental Customs Union. But let's also have a different orientation to this discussion. So, or let me put it this way, and I'll come to this point. What informs this model of integration? When you read, we will not read the whole of that provision. This provision has 4 key areas which are said to be the neoclassical model of economic integration. First, you start by creating a free trade area. Are we together? Secondly, you create a customs union, and these are sequential. Third, you create a common market. Fourth, you create a monetary union. They are called the Balasa model of economic integration. This guy, Bella Balasa, said for a country to be, for countries to integrate economically, they need to go through those phases. He's an economist. Balasa is an economist in the 60s. 60s or 50s. Yeah. So these are the stages. You first have to start having any economist, a trade economist, this is what they have in their minds. This is what they've been taught. You need to have a free trade area. When you are done with the free trade area, you need to have a customs union. After you have had the customs union, now you can transition and have a common market. The common market, this is where now the trade in services comes in. So basically, you start with goods, and then you go to services. Then, when you're done, you can go to the monetary aspects. You can have a monetary union. And of course, they say the fifth one, you can have a political federation or something like that. But I always focus on those four. The lawyers now have taken those four economic theories or principles, and they have codified them into law and said, this is how you integrate. Who says who? And when I did my PhD, I looked into this question. So then I was reading and reading and reading, and the bulk of the literature is talking about how important for the developing countries we need to go through these stages, this metamorphosis. We need to metamorphosize from being a free trade area. Now you change. You know, it's like a butterfly. You begin to change. You become the customs union. Then you can go to a common market, just like the way the European Union did. You see how the European Union did? It followed that theory. Now, but you're going to find in literature by economists who are saying, and they give rationale why that model will never work for developing countries. So I don't know now whether indeed in Africa, the fact that this hasn't worked for us, it is actually the vindication of those economists who said that model will only operate, and they qualify as to how it would operate. It would operate when you have all factors of production effective and operational. If you do not have the capacity to produce products, you're not going to be able to metamorphosize from an FTA to a customs union and all of that. Why? Because it means you are dependent on revenues that you secure from imports that come from other countries, including countries that are supposed to be parties to your customs union. Irrespective of whether it's an African country, if I'm from Lesotho and Egypt was not party to the AfCFTA, they export their beautiful, fruits and vegetables, very nice, they export to Lesotho. I'm expecting to get tariff revenues from them. If the fruits are from China or, I don't know, from Greece, also I am expecting to get from Spain, nice, fruits from there, olive, whatever, oil, whatever, I'm expecting to get the tariff revenue from there in order for my government fiscus to be operational, for me to get money to run my health care and what have you. You get the point? However, countries that have huge domestic base in terms of taxes, they don't depend on tariff revenue. And therefore, Europe can manage to go through those particular stages because it does not depend, its fiscus does not depend on tariff revenue. Yeah, I'll come. Are we together? So, this is a moment where I normally say, normally, in international economic law, our regulations, our laws are normally informed by theories. Those theories did not come from God. Those theories came within a certain context. For example, the economists will talk about the theory of comparative advantage. Have you ever heard about the theory of comparative advantage? To say Tanzania will sell what it produces most to other countries. And therefore, if you enter into a free trade area, the countries will now begin to exploit their comparative advantages. And therefore, on the basis of the theory of comparative advantage done by Adam Smith, a British scholar, done by Adam Smith, then it means you can open up your markets to receive products that come from other countries because you don't have those products. And then there will be welfare gains. Are we together? On the basis of, you see where economic law comes from? It comes from theoretical underpinnings. And the law seeks to now validate these theories. I know I'm not supposed to speak like this. I'm supposed to tell you, no, the Abuja Treaty is good, the AfCFTA is good. But I think scholarly wise, we need to also look at these elements. The theory of comparative advantage, that's why I'm saying theories have contexts. I wish to stress that. Theories have context. How did the theory of comparative advantage come about, which then led to the creation of this Balasa theory? Everything starts from the theory of this man called Adam Smith, the British guy. I don't know whether it was in the 1800s or something like that. The British, the British, it was a closed economy. Remember, they had colonies everywhere, supplying them with everything. It was a closed economy. And they had a problem. I can't remember the commodity. I think it was corn or something. They had a problem with one of the commodities, probably corn. And this guy said, okay, we are having a deficit in as far as this product is concerned. How do I convince the parliament to reduce the barriers to trade so that we can import that particular product into the British territory? Hello? He came up with a theory under the circumstances of strained economic activity whereby the British were running a deficit in terms of unavailability of a given commodity. There was context. The theory did not come about because he said, yeah, let's look at the whole world. In the Americas, in Africa, in East Asia, South Asia, how would this particular theory apply across the world? No. There was a context to the development of a theory. So it also means there was a context in the development of the theory of the neoclassical theory on economic integration, FTA, customs union, common market, as well as monetary union. Let me just say this. All these theories, when they were created, all of us, except for Ethiopia, we were colonies. Are we together? Yes. What the Abuja Treaty has done is to modify the neoclassical theory of economic integration because those steps are laid out exactly like that. Has that worked for Africa? I think the answer, I don't think, actually. The fact is no, it has not. The facts are there. The level of intra-Africa trade, 16%. 16. Our share of the global trade, less than 3%. So for us, unfortunately, the theory doesn't work. But I believe wherever you go, you'll always be told about how this theory is good for you. I think that the Abuja Treaty, of course, not I think, it's a fact. It has not been successful up till this moment. And now, I want to go to the issue of the, somebody had a question. And then I'll come to the issue. We'll talk about the AfCFTA.
Bon, moi, c'est juste une analyse, parce que je me rappelle encore hier, quand l'intervenant a parlé l'aspect des conventions. Et j'ai posé la question, est-ce qu'il y a une convention, il existe des conventions que l'Union africaine peut imposer à un État d'adopter ça? Il a dit que non, c'est impossible parce que chaque État est souverain. Maintenant, ici vous venez de parler de les créations de libre-échange, les créations de l'union douanière, etc. Mais jusqu'à aujourd'hui, on n'a pas encore commencé à appliquer toutes ces initiatives qui ont été faites. Maintenant, moi, je me pose la question, pourquoi? Est-ce que c'est un problème de l'organe politique de l'Union africaine parce que il n'y a pas une convention, un outil qui prouve que une convention que chaque État doit accepter ça au niveau de l'Union africaine. Est-ce que ça est-ce que c'est une conséquence de ne pas appliquer toutes ces initiatives ou pratiquer toutes ces initiatives au niveau de chaque État? Maintenant, je me pose encore deuxième question. Est-ce que ça suffit? Est-ce qu'on va seulement rester toujours comme ça alors que l'Afrique a besoin de la mise en œuvre de tous ces éléments-là qui a été initié au niveau de l'Union africaine? Je pense que c'est très important à votre niveau de continuer toujours à réfléchir. Voilà. Donc, ma question c'est pourquoi? Et pourquoi pas aussi au niveau de la politique là-bas, de l'Union africaine, la secrétariat, de commencer à imposer à chaque État d'adopter ou d'accepter une convention. Merci beaucoup.
Merci beaucoup. Merci. I was listening yesterday when we had this discussion, and the Abuja Treaty did not come with an enforcement mechanism attached to it. And I'm not as good a lawyer as Guy is, so whatever he was talking about, I haven't studied that. But it did not come with an enforcement mechanism with it. And even though countries took commitments, but when you look at the nature of those commitments, let me trace this back in my mind. Most commitments are attributed to individual state parties. So you have a commitment that DRC takes, and DRC will be responsible over compliance with that commitment. Correct? However, the nature of Abuja Treaty is such that it is what I would call collectivized commitments. It's collective commitments. Most commitments are not directed at individual countries. They are directed at the collection of countries, a number of countries. You get the point? So if countries that have ratified the Abuja Treaty, how are they going to implement it? It is implementable within a regional economic community, not within the domestic legislative system. You see what I mean? By the time you give effect to the Abuja Treaty in the domestic regulatory system, it means something should have happened at the REC level. So you wait for the REC to create a customs union first, and then you go back to the country to ratify. Actually, it even requires another layer of ratification. Because if it refers you to the regional economic community to say, if you don't have a free trade agreement, establish one. So you establish it within the REC. And you use the REC community law. And then you take the instrument that would have been negotiated at the REC level for ratification in DRC, in Kinshasa. But this is not the African Union law per se. It is the REC law. And then after you have done that, then you have to inform, I don't know how, because you see, the problem that you have with the Abuja Treaty is that, what do you call it? You are lawyers, right? What do you call this? It does not prescribe as to what is its relationship with the treaties at the level of RECs, Regional Economic Communities level. I want to say that again. Abuja Treaty does not prescribe what's its relationship with the FTA treaties that are going to be created at the REC level and the customs union treaties that will be created at the REC level. So after you've created them, then what happens? You see the point? So there is that deficit. Because if we didn't have that deficit, then it means COMESA would not have called itself a common market. COMESA calls itself a common market today. COMESA is not a customs union. But COMESA has several policies on competition policy and investment policy, which normally are policies you'll find constituting what would be a common market. So you have FTA, customs union, common market. So COMESA creates a free trade area. It skips the the customs union. Then it creates something that looks like a common market. The reason why I'm saying it's something that looks like a common market, it is because they have skipped the customs union stage. You see the point? Meaning COMESA has actually gone beyond what the Abuja Treaty prescribed. Because according to the Abuja Treaty, the common market was only to be created at the level of the African Union, not at the level of RECs. Are we together? You see that? I did not read that provision. The common market, as per the Abuja Treaty, is only meant to be created at the level of the African Union. There has to be a continental common market. There's not supposed to be the regional common market. Because all that our member states were supposed to do is create FTA, create a customs union, then the next step is to create a continental customs union. I have 8 minutes. And then create 7 minutes. And then create a continental customs union. Now, within the continental framework under the Abuja Treaty, that's where now you'll create a customs union. Are we together? The question you must ask yourself is, the enforcement part that was asked, but did anybody even make an effort from the African Union Commission, African Union member states? Was there ever an agenda that perhaps maybe the legal council raised and said, we as the office of the legal council, we are seeing this and that and that and that, and we need the member states to be aware of this and that, and then we are recommending this and that. Are we together? Now let's talk about the AfCFTA, the question that my brother raised. First, the FTA part of the AfCFTA. Remember I said the AfCFTA has different legal instruments. Protocol on trade in goods, protocol on trade in services, protocol on investment, blah, 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 right? The FTA part, because it only relates to trade in goods, it now would only relate to the AfCFTA? What was I saying? No. So the AfCFTA, the part that relates to FTA, Free Trade Area, is the AfCFTA protocol on trade in goods. That's what would relate to what the Abuja Treaty is talking about when it talks about RECs having to create the FTA. Right? Are we together on that? Secondly, the AfCFTA is not a REC. So the AfCFTA was not foreseen by Abuja Treaty. And therefore, the AfCFTA itself is running contrary to the Abuja Treaty. It was not foreseen by the Abuja Treaty. Same member states. Hello. Same member states. Sawa. In Swahili, yeah? Sawa. You okay? It's like somebody died. the way folks are quiet. So I wanted us to have this reflection because it now the questions that you as scholars will have to you have to debate is the status of Abuja Treaty now that you have the AfCFTA, now that you have the RECs that have created themselves common markets that were supposed to have been created within the continental framework. In the African Union, some members are saying, let's now think about creating the Continental Customs Union. So I was like, same member states talking about the Continental Customs Union, but what about the Abuja Treaty? It's like it doesn't exist. It's like anecdotally they refer to it. I'm like, what are you talking about? You made commitments. The best you can do, go to the Abuja Treaty, revise the damn thing. Sorry for my Chinese. Go and at least be legally consistent. Look at what has happened, revise it, and then, if you want to terminate it, fine. Terminate if you want to terminate. But you can't have legal instruments on the same subject matter, but saying different things. You can't. It's oxymoronic. So for those of you who are studying, who are students, go deeper into this particular subject matter. Now, the same AfCFTA, already we looked at the different protocols that it covers. The AfCFTA is now like COMESA because it has the protocol on trade in goods, which will be equivalent to FTA, which is about trade in goods. It doesn't have the customs union, but it has rules and regulations that relate to competition policy, IPR, intellectual property rights, investment, what else? I said competition policy, digital trade. These are more on the services side, and also it has the protocol on trade in services. Are we together? So already it does not adopt the model of the Abuja Treaty. Conceptually, I am very happy with that, because I think it makes sense that our liberalization is holistic liberalization, not sectoral liberalization as prescribed by the theory of neo-classic economic integration, whereby you do goods and then you go to services at the common market level. No, you need to liberalize goods and services at the same time, because a full truckload of mangoes from a country X, those particular mangoes are goods and the rules on goods will apply. The truck itself and the driver, the rules that will apply will be trade and services. So you can't open the other sector and leave the other one closed. So you can see the African Union's departure from the Abuja Treaty, which was driven by UNECA, and UNECA is an organization that is made up of economists. So you can see the neoclassical understanding being the bedrock of this particular legal instrument. I'm told you have to eat. So then when we come back, we'll take the questions. I hope that's okay. All right.
Flowers. Thank you. So before we go to it, I just wanted to make